We have the issue with the subpoena to Meta and the trial setting, which is for Tuesday, the 19th. So, Mr. Emerson, I did see the objection by Meta's lawyers. What would you like to do here?
Let me just remind the court where we are factually. We filed a subpoena, Ducis Tecum, a while ago, several weeks ago. It was set for return last week, which Meta did not respond to via filing a motion or a motion to quash or an objection, nor did they appear in court. And we set this over today. The court had us submit a subpoena to Your Honor for Your Honor to sign. We then served that on them, and we got that letter yesterday objecting. What we're asking for in terms of relief today, and I'll give some reasons for this, but I want to lay this out first, is we're asking the court to issue an order compelling the production of the documents, and also to ask Meta to show cause as to why they have not responded to the original subpoena properly, did not show up in court to address it both last week and this week. It may be too early to reach this conclusion definitively, but it certainly feels and smells like Meta thinks that they don't have to respond to this court, that they can do whatever they want, and essentially is telling this court to go jump in a lake. The arguments outlined in Meta's response are simply mostly false. Invoked a civil procedure to avoid a criminal procedure, and you'll notice that they rely heavily on Rule 45, Your Honor. But a criminal rule, that's a civil rule. Criminal Rule 17 is what governs here. And under Criminal Rule 17C, the exclusive avenue for challenging a motion to quash is filing a motion to quash with this court and then potentially showing up. So they filed nothing, as I indicated. Their letter is not a motion. Their letter cannot quash a criminal subpoena, and the subpoena should be enforced. Now, it is our position that they've already violated a court order by not responding to the subpoena, which was signed by this court. It wasn't just issued by myself. It was signed by this court. One of the main arguments made that I find alarming and why this smells so bad is that Meta is trying to argue that this court has no subpoena power. And again, we talked about this last week, but they seem to suggest that they can't be touched in Colorado. They really can't be touched anywhere unless it's Delaware, unless it's 100 miles from Menlo Park, or unless we go through a lot of out-of-state procedures. And they rely on a case called Colorado Mills LLC v. Sun Opta, which is in their letter, and they rely on that improperly. So what that case essentially finds is that if the company, the corporation has no business, they have no offices, they don't do anything in the state, they don't have a registry agent, well, in that scenario, then maybe there's other procedures that have to be taken. But when a company does, like Facebook, have business, Meta have a business in Colorado, they have an office in Denver, they have a registered agent who we've served twice with a subpoena. When those two factors exist, when they actually conduct business within a state, they are subject to that state's courts, to that jurisdiction of those courts. When a company registers to do business and appoints an agent for service, they're basically consenting to that form's process. And so that argument just fails, that there's no jurisdiction. I think this court knows that it is jurisdiction. We're looking for IP address information, logins, things of that nature. It's very clearly spelled out in our subpoena. And so the argument about the SA frankly misses the mark. They are either confusing Rule 45 and Rule 17 because they don't do criminal work very often, or they know that Rule 17 applies here, but they like Rule 45 better. But so they've now failed to respond properly twice. They failed to show up twice in court. I did email the attorney. I can't remember his name. He said he was not going to show up today. So that confirmed what their intent was. And it feels like their intent is to basically thumb their nose at this court and not respect the jurisdiction of this court. So
okay. So people, thanks for your patience. Do you have any position on what Mr. Emerson just stated?
Your Honor, I don't think we take any position on it.
Set a show cause hearing, issue an order. I think we already have the subpoena, which is an order. Mm-hmm. I could issue a show cause as to why they shouldn't be found in contempt for violating my subpoena order.